Hello, welcome to this discussion about legal risk. My name is Steven Francis. I'm an Executive Director in EY's Financial Services legal practice.
I'm Matthew Whalley. I am a Director in EY's Financial Services legal practice, and I'm responsible for our legal risk business.
My name is Simon Nasta. I'm the General Counsel of FBN Bank. FBN Bank is one of the largest banks in Africa, and we're a UK bank, and I'm in charge of legal risk.
So legal risk is a topic which I think it's fair to say probably wasn't much discussed 4 or 5 years ago, but it's very much come to the fore. It's something which many financial institutions are trying to grapple with, and as we're going to discuss, has very significant ramifications for in-house lawyers and the functioning of a legal department. So Matt, is that right? And why has it become a more significant issue now?
Yeah, I think it is right. I started working in legal risk around 2010, 2011, when it was pretty new. So set up the first legal risk framework at one of the big global banks. And that was at a time when actually there were very few financial services organisations really exploring what legal risk meant, what the financial reputational outcomes could be were legal incidents were legal risks to be realised. So yeah, I think it is right.
Okay. And just so that everyone is clear, is there an uncontroversial definition of what legal risk is, or is it one of those things where people look at it and define it in different ways?
I'm not sure much in the legal world is uncontroversial, but there are a number of definitions that started. I mean, the first one was 2003 when it was defined as part of the Basel II documentation, where it was defined as part of operational risk. The IBA have a definition that has been circulating for quite some time, and we obviously have got our own definition that we published in a paper earlier this year that tries to simplify legal risk, divide it into easily understandable and digestible parts, so that clients, in-house legal teams, businesses can actually start to understand what it is and how it affects their business.
So, help me with this. What are the discrete identifiable parts that make up legal risk?
Essentially there are 5. So first of all, legal risk is about the interaction of law and regulation with business. So it's about a business's operational processes. There's another aspect where law and regulation can change, where interpretation of law can vary, and that's a sort of form of legal risk that originates in the law itself. But as far as businesses are concerned, actually it's your interaction with law and regulation that represents potential risk. The clearest way that I've found to help define legal risk is to formulate sort of 5 categories of interactions. So legislation and regulation, legislative regulatory risk, which is the legislation and regulation that applies to your business, its operations, its processes. Contracts, all of your contractual estate is a core interaction between your business and the law. Non-contractual obligations, which is probably the biggest source of risk currently in terms of duty of care and any potential failure in duty of care that you have towards customers in the market, certainly financial services. Non-contractual rights, which in FS hasn't been traditionally a significant source of risk, but I think the importance of brand nowadays as digitalisation is starting to take the fore and banks are going to rely more strongly on their brand, the ability to protect and to leverage that brand is going to make their intellectual property more important. And finally, dispute. And when we talk about disputes, not the risk of being in dispute, because by the time you're in a dispute, you've normally mismanaged, or you perhaps have mismanaged something further down the line. But the strategy that you take within a dispute that can help to affect and manage down the quantum of loss.
Okay, I see. And Simon, in FBN, how is legal risk managed there, and what role do you play as an in-house lawyer within FBN's legal risk framework?
It's interesting that you started off with the definition of legal risk, actually, and you were talking about, is there a standard definition of legal risk? That's one of the things I guess we grappled with, and I guess all organisations grapple with. So first of all, we tried to come up with a definition of legal risk, and actually our friend here, Matt, was very helpful from that perspective, because we got some very useful advice from him on that perspective. We also took a similar approach in relation to categorising risk into certain different categories, exactly along the same sort of lines that Matt is talking about. The one very difficult thing we've had is, and I think this is something that all lawyers probably grapple with, is how do you prioritise those risks and how do you quantify them? Because some of these risks, and one would hope, will never materialise. So it's quite hard to necessarily get some real grounding, some numbers behind them. But of course, when you ask FBN, how do we deal with it? So once we've done all that, we need to give that analysis and those figures up the management chain. So we present, if you like, we present at Executive Management Committee, and we would also present to board. But they really want to know, what are the things that, if you like, keep me awake at night? What are those legal risks that worry me? So coming up with a model that Matt was talking about, with having a definition, defined categories, and a way to actually quantify them and prioritise them, enables me to distill that into, if you like, a snapshot, which I can then present to board to try to let them know the legal risks that worry me and how we're mitigating them, if you like.
Okay, that makes sense. And so let me ask you this then. You do, I would imagine, in your team at FBN, legal work which involves executing contracts, giving advice to the business, and so on and so forth. Is the reporting to the board about legal risks issue and thinking about legal risk, is that a relatively new innovation? Were you and a fellow in-house lawyer colleagues in different organisations worrying about that to the same extent 3 or 4 years ago, or is that a relatively recent thing?
I think that's an excellent question, and it highlights the point very well. And the honest answer is, I think it's not something that we as lawyers were thinking about before. And if you look at the birth of legal departments have really grown to mitigate transactional risk. If you think about it, in the financial industry, the majority of products are contract-based. If you like, legal risk is a part of operational risk. So the skill set of a lawyer isn't necessarily to be a manager of operational risk. It is to highlight legal issues, perhaps in a transaction or in a dispute strategy. So yes, I think it's very fair to say that legal departments 3 to 5 years ago were not thinking in the same manner on legal risk as they are today, and perhaps we're not even aware of it in that way. I think they were very much mitigating legal risk by working on transactions, looking at the pitfalls, highlighting issues, thinking of ways to get around them to reduce that risk, but I certainly don't think they were thinking of it in a strategic way, which is certainly the expectation and requirement today.
So Matt, let me ask you this. Based on what Simon has said, are lawyers the best people, in-house lawyers, to be managing and taking ownership of legal risk? Is that typically the way it's done in financial services businesses? Are there other ways that firms approach legal risk?
So that is a really difficult question, right? Because actually, because it's a relatively new discipline, it's yet to be decided who are the best people to manage it, I think. I think within firms in financial services, it generally falls on the in-house legal function as an expert in the law to take responsibility for legal risk. As Simon was saying, lawyers are generally hired to help with transactional work or to manage litigation. So neither of those two disciplines lend themselves towards a second line of defence role. In 2012, the FSA were keen, as it was then, were keen to reinforce the role of the general counsel and the in-house legal team as a second line of defence function, which has led to some confusion with in-house teams, I think, as to if you are employed on a transactional role, then that's a first line activity. Or if you are involved in regulatory investigations or in litigation, often that's a pseudo third line responsibility. So this whole second line risk management function, which is more strategic, where you start to aggregate risks across risk categories or look at it down particular business lines or geographies and put together good management reports for the board or for other forms of senior management to make strategic decisions with a full view of the legal risks in mind. That's quite a new discipline for lawyers, and also it's something that other forms of risk management grapple with as well. So I think lawyers have to be involved. It's a very long-winded way to answer your question, but lawyers have to be involved from their expert perspective. They are the ones that can interpret the law and have a view on the risks. But you don't need to be a lawyer to aggregate risks, adult risks across contract types, for example, or to build good, meaningful legal risk reports. And often lawyers tend to get more involved in the detail and more involved in written reports rather than the more keenly visual red, amber, green graphical reports that tend to make a bigger impact at senior management level and are more effective at getting the message across as to where a risk is across an entire business rather than within a particular high-profile transaction.
Yeah, that makes sense. So Sam, let me ask you, some of the skills that Matt has spoken about there are skills which I know don't exist with some in-house lawyers that I've dealt with. And I'm not denigrating them, it's just a discrete set of management activities which typically lawyers don't do. In order to do that role at FBN, do you need particular sorts of training as an in-house lawyer? Do you learn on the job? Do you take advice from specialist risk advisors in the business, and so on and so forth? How are you able to do what is quite a new, and it sounds to me quite challenging role as an in-house lawyer who normally deals with transactions or if you do litigation, bits of litigation?
I think the reality is, since the crunch and the birth of increasing amounts of regulation, the role of legal departments is to be as agile as possible. I think exactly as you and Matt have highlighted, this isn't legal risk, and quantifying it and producing meaningful MI doesn't fall in the skill set of the traditional transactional or litigation lawyer. So inevitably you can call on outside help, and quite frankly that is a very helpful way of looking at it, because Matt described the traditional sort of MI that management would require. I think you referred to red, amber, green.
Yeah.
And lawyers are very good at Word, they're not very good at Excel, they've probably not got the experience of having to present such reports, the sort of reports that would highlight those risks to management. So we can easily get lost in the detail. Now clearly when you're at board, they don't want the detail, they want the high level. So I do think that is something that doesn't necessarily fall into the natural skill set. But the reason why I use the term agility is I think it's the role of the GC to start with that agility, because if you like, you don't need to bog your team down with that level, the sort of, if you like, the scanning sort of role at the top to see how the legal risk is and to quantify it. You can leave them in the transactional and the dispute. It's great to try to give them those tools to assist you and also to train them in legal risk as well. But it's more the role of the GC to be agile and to gain that skill set and to learn how to present. But I wouldn't say this is a problem purely for the legal profession. I think, if you like, the requirements for good MI and the regulatory expectations of good MI and what people should and should be presenting and how we document challenge and all those things, I mean, they're very topical across all industries right now.
And you do see, I mean, there's an impatience with within some boards that they aren't getting information from the front line of their business to help to inform their decisions. So the quality of MI that gets pushed up through to the board. That I had a great phrase a few months ago where obviously the boards are responsible for setting the tone from the top, but they have to be able to hear the echo from the bottom. And getting that echo is very difficult, because you have to get the sum of such a large group of people, a wide range of activities. You have to understand what you want to learn from any data that is being generated by those activities, so you can actually paint a picture of that data that helps to inform your future strategic direction, product development, conversations with regulators. There's a huge raft of decisions that you can make, that you can be more informed at making if you get the right information from the bottom. But it's an incredibly difficult thing to get right because of the volume of information that's there.
I think you raise a really good point there, Matt, because when you say echo from the bottom and tone from the top, and you've also, Stephen, you've talked about, if you like, legal risk being a new area. Let's not forget, for the board, legal risk is a new area. So one of the things I find is helpful is to remind everyone exactly what legal risk is, what categories of legal risk that we are concerned with, at the sort of as an introduction before I present my MI, just because I think it's a new topic for them as well.
Mm-hmm. So let me pretend to be cynical about this for a moment, okay? Is it possible that this is just another way of presenting to the board information that they already had, and it might have been called operational risk or something else? Are we talking about something which is fundamentally different, or are we just talking about a reordering and tidying up a nomenclature change to things which have always been happening? I'm trying to work out, Matt, how much substance is there in this topic?
So it's a bit of both. Legal risk hasn't just appeared since 2008.
There've always been contracts.
Yeah, there's always been law and regulation. There's always been contracts. You've always had IP. You've always had a level of duty of care, and you've always had litigation, and you've always had in-house lawyers. But the level of financial loss related to legal risk incidents through regulatory fines, through increased cost of litigation, there's been a step change. Probably in the UK, 2012, 2013, there's a significant difference in the fines being issued by regulators for things that can be related back to a form of legal risk. So non-contractual obligations, for example, on the conduct agenda. It's all about duty of care that you have towards customers, towards the market. The litigation costs, particularly coming out of the US, the big US banks, billions of dollars on litigation over the last 5 years. The financial outcome of getting legal risk wrong is so much greater now that there's more of a focus on it. It's one of the reasons there's more of a focus on it. But because any company has to integrate with law and regulation throughout its operational processes and its relationships, it of course has to some degree been managing legal risk already, but it's not necessarily been reporting it as a risk category. So you don't get a good view of what are the day-to-day risks or the day-to-day costs of mismanaging contractual obligations, failing to meet your contractual obligations. It's not something that's been a focus. The sheer scale and complexity of law and regulation that's coming down the pipeline and that's come down the pipeline already since 2008 is huge. So there's a greater scale of risk coming down just from law and regulation as it comes down the pipeline. And in the middle of this, you've got in-house legal teams that are employed to deliver transactions and to consult on litigation. Their workload is increasing significantly because of the level of legislation regulation, because of the litigiousness of society, because of the change in attitude of regulators towards non-contractual obligations, and now we've got digitalisation and effect on brand. There's a huge amount of change that is all being directed at this fairly small in-house department, the legal department, and they have a responsibility to map where the risks are from all of these environmental market changes, from all these changes, to map how they affect their business and to report those through, so that when you run a business, you actually have a good view of what's probably one of the core risks that you face as a business. Getting legal risk wrong is a multi-billion pound issue in financial services, and certainly has been over the last few years. So I think there's a lot of substance, there's a lot of overlap. It's important for those in-house teams to lean on other departments where they can. Compliance certainly have an important role. Risk management, fairly obviously you would think, but the working relationship between legal teams and risk management teams is really important to getting the legal risk identification, quantification and reporting right. So there's a lot of substance, there is quite a lot of overlap, but having the in-house legal team's voice speaking more loudly at board level about where the legal risks are, about what the legal consequences are, is an incredibly important development in long-term sustainable business success.
Now, one of the things that you were talking about there, I wanted to run this one past Simon. You were talking about compliance, risk, audit, and so on and so forth. So in FBN, for example, Simon, is it pretty obvious what categories of risk are legal risk, what are compliance, what are operational, to avoid the double counting problem? Or is that a problem that exists and there needs to be a good degree of working the issues through so that there is a reporting format where everything is included in a report to the board, but there's no double counting or overlap and so on? Did it take a bit of time in your organisation to get the legal risk framework right and fit it into the other internal control functions that report to the board on risks in their area?
Yeah, no, I think absolutely. It's certainly an evolutionary process, because I think some of what you were saying in your first question to Matt about is this a new area or not a new area, and in Matt's answer to the heightened role of legal risk. So it's not a new area, but there is obviously the danger of double counting because people have already been looking at it. So if you like, conduct risk is a legal risk, but it's something, and that's a new area, but that's something that perhaps compliance feel they own. It's a bit of a crossover. I think under the BAL it's certainly listed as a legal risk. So you can have a danger crossover between the different functions, and also how do you, as legal, fit into the operational risk model? Because legal risk is, of course, just a part of operational risk. So you do need to be a little bit fleet-footed and evolve to work out where you fit in, to ensure you don't confuse the board, to ensure your stats are actually credible, because you don't double count. So, and I think that process is probably, I would certainly say it's ongoing for us, but I would imagine it's ongoing for the industry, as we as a profession are learning about legal risk, as other people are learning what legal risk is, so how you fit in and how you report. And I think it's almost the responsibility of a bank, if you like, the overall person who's responsible for operational risk, to ensure you're using the correct metrics, you are all fitting in together. So it's almost that responsibility to ensure there's not double counting sits elsewhere, certainly in a coordination role, but you need to be alive to it yourself.
I'm just going to pick up on that, because there is an element of duplication, and that's inevitable because this is quite a new discipline. But it's better to have a small amount of duplication than it is to have this pretty important risk area falling between the cracks.
I wanted to ask you both one other question, because it seems to me that this whole development is not without its risks. One of the risks might be, for example, that once upon a time, in-house lawyers advised the business, and they were advisors. And the FCA, for example, the regulator, was quite happy to see in-house lawyers as advisors to the business, and the business took responsibility for the outcome of whatever that advice might generate. So if you look at FCA final notices, you will see compliance being criticised, the board, internal audit, the first line. Everyone will receive their fair share of criticism, but nowhere is there any mention of the in-house legal advice that might have been given which causes problems. All right? Isn't one difficulty going to be that if lawyers are now owning legal risk, which is something that the regulator is very interested in, they now have to be above the kind of parapet and take a degree of responsibility. And so that a useful ability that lawyers had to give legal advice in a privileged environment where no one ever gets to see what that advice is, potentially, is now undermined by lawyers taking a front line legal risk role. Is there any risk of that?
In-house lawyers have, for as long as I've worked with them, been trying to establish a seat at the top table, been trying to articulate their value, been trying to position themselves as strategic advisors to the business, and not just be the person that gets told about an incident when it's already developed and just become damage control. They've been trying to get to a position where they can advise the business from the earliest stage possible and prevent legal risks from actually realising. So they've been trying to do legal risk and working towards legal risk at an individual level for at least a dozen years, quite successfully in a lot of firms where you've got GCs sitting at the board, executive level. With that increased responsibility comes a level of risk, but also increased value, and being able to articulate your value as a general counsel, or the value of the function that you run in terms of the extreme legal risks that you're helping to prevent, the day-to-day profit leakage from legal risk that you're managing to reduce, as well as the time you're spending facilitating transactions and bringing down quantum of dispute. Actually, you have a much better and more compelling case and proposition as a general counsel with legal risk management responsibilities than you do as a more traditional advisory, reactive advisory arm.
What do you think, Simon? Is there a danger in the development that in-house lawyers suddenly become open up to a degree of scrutiny that before they were able to avoid?
I think there certainly is a danger, but I think to go with the assumption that they didn't have a level of responsibility before would be wrong. Certainly, perhaps not necessarily a regulatory responsibility, but put it this way, for us, one of the things that makes FBN different to another bank is we have an awful lot of African legal risk. So we have exposure to 27 African jurisdictions from London alone. Inevitably, that leads you to making certain decisions because you're the most qualified person to make those decisions, because you're perhaps the best person to interpret the local law advice you have. Unfortunately, in making those decisions, I think a certain level of responsibility and accountability comes. So I think at a business level, you've always probably, the advice you give at times, unfortunately, comes with a level of accountability. There's no doubt about it. But from a regulatory perspective, yes, I think that's right. I mean, one of the concerns I have at the moment in relation to the debate about senior persons regime is this debate about whether a GC is going to be a senior manager or not. From my perspective, I find day to day I will frequently come across occasions where I'm either as a member of ExCo advising the other ExCo members in a legal manner, and at the moment that's certainly there's the protection of privilege, and it's the same with the board, but there is definitely the possibility of an erosion of privilege there, and that certainly concerns me as a lawyer.
So this is the last topic I wanted to cover, and Simon mentioned it there. So the FCA have a senior managers regime, which replaces their current approved persons regime for many significant institutions, banks, large asset managers and insurers. One of the discussions has been whether in-house lawyers should be SMFs, whether they should have a senior management function, and the FCA is consulting on this at the moment. Now, Matt, what in your view is likely to be the outcome of this, and what are the issues? What are the practical issues for in-house lawyers? Should the FCA go one way or the other?
Okay, so the short summary is, yeah, I've had discussions with a number of financial institutions and some industry bodies. On the in-house side, there's an almost unanimous view that in-house legal team has to be captured within the SMR, because it's a core function and it works, it's part of a business. It needs to be managed within that business. It can't be carved out. There's less clarity, or there's less accord as to whether the General Counsel should be named as a role, should be named specifically as a senior manager role. And I think that depends on the size of the firm. If you're a big global bank and you've run a legal function with 1,200 people, you probably would need to be captured as a senior manager for that function, because that you need to have genuine oversight of the function. If you run a 4-man legal department as General Counsel, then you probably don't, because if you report to another senior manager, it's fair to say that that other senior manager would have adequate oversight over your function because of the size. So there's a scale factor. Practically, I think it's helping in that it's bringing a bit of clarity around the role of the in-house legal function and the fact that it has responsibilities for managing legal risk. A useful outcome would be articulating legal risk as an activity within the rules, so that it has that day-to-day focus and people understand that's a key part of what in-house legal teams should do. And the main focus is going to be on evidencing how well a legal department is performing its job from an operational perspective, more than from the quality of advice. So the concern around quality of advice, I don't think is trying to be captured. It's the operational management of the legal function, how it goes about its day-to-day duties, how it evidences that it understands where the legal risks are, that it's taking the right steps to manage those, that it's giving the right information up to board level on those risks, and that it's you've got a fit for purpose legal department. So the biggest focus, I think, will be on the operational side practically.
So in a firm like yours, Simon, in FBN for example, is it going to be very easy for you to separate out the legal risk management that you do, and you as the head of a legal function which does legal activities, from you as a legal advisor who provides advice? And I suspect on many occasions you wouldn't want a regulator to see that advice. They wouldn't see that advice if it came from an external lawyer. Why should they be entitled to see that advice from you? Is that going to be an easy thing to do in your organisation?
I think it is, because I think we are a simpler organisation than, if you like, the picture that Matt was painting of a more complex organisation, say with someone responsible for 1,200 people. And I think inevitably this is a problem with a solution which isn't one size fits all. So for us, I think it's relatively easy. I mean, I report to the CEO and to a board committee. The CEO certainly would have that oversight. So for me and for us as an organisation, I think it's relatively simple. I don't have a huge team. It's relatively straightforward. But if you're a large clearing bank and you have a huge number of lawyers underneath you, I think it's a very complex question indeed. But I very much support your view when you said in your question, why should the advice that you give be any different to the advice that is given by a private practice lawyer? And I think that's absolutely fundamental, because increasingly, if you like, as a way of mitigating legal spend, firms are recruiting more lawyers to give that advice. So then it can't be that there's a different rule for the in-house lawyer to the private practice lawyer. It's a very difficult question.
Well, I think we've covered all the topics. I'd like to thank Matt and Simon very much. I just wanted to highlight a couple of points, actually. First of all, I think this is an area to watch very closely. There's bound to be a significant amount published about legal risk, how it's managed within organisations, and what the particular challenges are. I would also highlight keeping a close eye on the outcome of the FCA consultation, because, as I say, lawyers in financial services businesses have managed, if that's the right expression, not to be the focus of the same level of criticism as other functions within banks, insurers, asset managers have been. And it may well be that that's about to change. Who knows? It may change the function of the in-house legal department, the way they operate, and it may have ramifications as well for legal risk. So I think there's an awful lot in the topic, and it's bound to develop into a very significant area. Thank you.
Thank you.
Thanks.